Hello and welcome to the Federal. I am Nilanjan Mukhopadhyay and you are watching our program Off the Beaten Track. This is a program in which we pick one issue and speak with one person in depth, exploring various aspects of it. We normally pick up something that is happening, very important topical at the moment, or something which is actually embedded in the past, but also very important, having a deep impact on the present. In August this year, actually just days before the 76th Independence Day, the government suddenly and very dramatically, without any prior information, brought in three bills. These bills would fundamentally change the criminal jurisprudence system of the country. These bills, called Nyay Sanhita, Nagrik Suraksha Sanhita, and Sakshya Sanhita, replaces the Indian Penal Code, the Criminal Procedure Code, and the Indian Evidence Act in the same sequence as I read out these. These have been said, that these bills, because it completely overhauls the criminal jurisprudence of the country, are said to be as dramatic as demonetization was. Suddenly something happens without any discussion. Within a few days, procedures started, and we realized that these laws will actually have a new definition of the types of crimes that are there. There will be new procedures, and there will be new rules to submit evidence in courts. Very recently, just about last week, the parliamentary committee which went into studying these laws submitted its report. The opposition members, by and large, most of them, submitted dissenting notes. Even the basic demand which was made that these laws should not have Hindi names because of the wide linguistic diversity of the country have not been accepted by this committee. It is expected that the government will go through these recommendations made, and then in the winter session of Parliament, when and if it is held, these would be passed by Parliament. To discuss these dramatic changes as to how it is going to further empower the government and disempower the citizens, I am joined by a very eminent lawyer in the Supreme Court, Mr. Sanjay Hegde, who has been a very known voice for the underprivileged and the downtrodden, and those who are being steadily impoverished by the law. Welcome to this program, Mr. Hegde.
Thank you, Nilanjan, for having me.
It's a great privilege to have you once again speak with you on an issue which is actually going to affect the day-to-day life of every citizen. Very recently, you wrote an article also in a newspaper where the headline was actually very dramatic. Coming soon, Code Modi in the Amrit Kal of Indian democracy. In the opening itself, you list out various quotes right from Moses to Hammurabi to Napoleon's code. Can you just explain as to why you are linking to these codes which have generally had a very negative connotation about them in history whenever we read about these legal systems and legal codes in the past?
No, see, every powerful ruler, ultimately, he wants to lay down the law. What I have given a legal code. So it was Moses who went to the mountain and brought down the 10 commandments. Hammurabi's code was one of the earliest codes for which we have evidence. After that, you have Justinian, you have Solon, a lot of rulers. If somebody was known as a just ruler or unjust ruler, you have the Manusmriti, for instance. So often the lawgiver is the man in power. And a man in power sometimes either out of necessity, when there are too many laws and all that, or there has been a lot of confusion. Sometimes you say you scrap the whole system and you come out with a new system.
Right.
So the act of bringing down the truth on which you can have an operating system as a way forward, that is an expression of power.
Mhm.
So, given these historical instances, in a way, Mr. Modi, who always likes to look back at history, look back at grand gestures, this is one more grand gesture, just like demonetization was. Totally.
Eternally would be remembered in history, demonetization. Similarly, the new Sanhitas would be looked as, being part of history eternally. That these were the
Yes,
laws by Mr. Modi.
yes, for instance, all lawyers and non-lawyers call the Indian Penal Code Macaulay's Code.
Right.
Macaulay drafted it. It was a new code which sort of standardized the criminal law for India as it stood in British times. Napoleon came out with Code Napoleon, which is the basis of the European legal system in many countries now. So, in a sense, the idea of a Code Modi is a logical extension to a political organization which believes that post 2014 they are remaking a new Bharat.
And
So
we
I don't
eventually-
think the historical parallels that I've given are wrong.
But to be the devil's advocate, the government says that this is a part of the decolonization which has not been done in the past 76 years. That Indian laws were actually drafted by the British for a subject citizen, whereas we are actually citizens of our own country, so we should have our own law in our own language.
Well, I would have accepted the argument if you had treated your citizens as your equals and your masters. If you do not give them the same rights that the British gave them, or the same concepts that the British gave, and in fact, you have made the system, or you're proposing to make the system much harder against the citizens than even the colonial masters did. So are you doing a good idea or a bad idea? You can say that the British are bad, but you can't say that I will come up with an Indian idea which is worse. Now, I also gave, in that same article, I gave an example of the railways. The British did bring in the railways. They brought in the railways because they wanted to move their troops fast enough from the cantonments to various trouble spots. Now, if you say that I am going to decolonize the railways and I will have a Bharatiya gauge, then what do you have to do? You have to rework all the bogies, all the engines. You will have to rework the signaling. For what? Just to say I have something Bharatiya. And ultimately, railways or any mechanical vehicles have to obey the laws of physics, no?
In fact, you write in that article that even the signaling systems would have to be redone and a whole host of confusion would have to be endured just so that we could claim we owed nothing to our colonial past. Essentially, what you are saying that this is essentially just to create a symbolic grand gesture that we have eliminated the past. There's nothing British. It's all pure and simple Bharatiya. What I find is when I'm listening to the discourse around various people who are actually committed to the idea of Hindutva, the politics of the Sangh Parivar, there is a very close connection. This is being seen in conjunction with this entire new thing which was started from around the G20 summit of India versus Bharat, that Bharat is what we are going to be calling ourselves. There is going to be a greater push towards that, all aimed at harnessing political support for the Bharatiya Janata Party in what many of us who have looked at the politics of Mr. Modi and the Sangh Parivar is the Hindutva belt, which is essentially North, Central and Western India. That is how actually, if we actually try to put the region through the map of India, leaving out South India, greater parts of East, the Northeast, of course, and also some parts of Northern India. Now, this kind of would you say that this is actually bringing in a new legal system driven by parochialism, political parochialism?
Well, there's a certain amount of parochialism in insisting on Hindi names, even when you're drafting the thing in English.
Right.
So if Hindi had been a common language throughout the country and everybody thought in Hindi, and then you were describing legal concepts which you drafted first in Hindi and brought it about, maybe there could be something said about this argument. But this is again like the bullet train which is imported from Japan. You're going to put it on India and then say, oh, we have done something. So everything is drafted in English. A large portion of it continues the way it was. Most people who have studied it.
You point out that 80% of the 3 new laws is virtually the old laws. But
Yeah.
possibly the 80% is not important. It's a 20% which has been changed, which actually dramatically undermines the legal powers of the citizen, and enhances the role of the state and the enforcers of law.
It does. It does. See, those who ran this through even computer programs which look for plagiarism and all that have calculated that it is between 80 and 90%, mostly the same thing, except that the sections have been renumbered, gone up and down. That is a regular process. It happens in all kinds of laws. Sometimes certain sections have to be reworked, certain things have to be done. The company law, for instance, got changed. All these things happen. But that is an organic part of pruning, shaping the law, which happens in the normal course. Now what you are saying is that I will chop everything, regraft the head on the foot and things like that, then claim that I have a new thing altogether and damn the consequences. And yes, you do not aim at giving more power to the citizens. You have seen nearly 75 years of independence, where despite everything, it is the policeman who rules, the thanedar who rules. Any citizen who is called to a police station does not go there willingly. Any citizen who has even in some slight work in the police station where he is not at fault, where he has got to go and register an FIR, for instance, even there he goes unwillingly. You have done nothing to reduce that imbalance, but on the contrary, you've now made things much more tough for the citizen. You have now left it to the policeman to take a call on whether to register a complaint or not. How many of the poor who go to the police station, even today, face such huge problems in getting their complaints registered, in getting their FIRs registered, and much less to have a fair and independent investigation? That's one. Secondly, you see, the system as it now exists says that, if you're arrested, you're brought before a magistrate. The magistrate says that, okay, I'm sending you to the tender ministrations of the police. That is, I'm sending you into police remand. And, all that, the police remand happens within the first 15 days. Thereafter, the police, they can't keep you endlessly with the police. Because all of us know that if you are in police remand, they can use any tough measures, and very often they do. Strong arm measures, third degree, deprivation of sleep, so many other things. So the
absence of facilities in most custody rooms, in police
stations. Absolutely, all those things. And then thereafter, you can apply for bail, or the court may say, no, I'm going to take you into my custody till I can figure out when the trial is going to happen.
Right.
Now, but people knew that at the end of 15 days, things wouldn't go worse. You would get that slight relief of judicial custody. Now, what it is said is that overall, as long as the policeman is investigating for a period of 60 days, maybe a period of 90 days, or even more if he can convince the judge, he can take you into custody for an overall period of 15 days. And even more if the judge allows. And so therefore, he can immediately take you into custody for 1 day or 2 days, then say, okay, I'm finished with you, return you to the judge. Then thereafter, after 15 days, suddenly take you back into custody and go on, so on and so forth. An unending Chinese structure. And in that period of 90 days or more, where investigation continues, the magistrates will just then say, no, I can't, I will not free you on bail. I don't know when the policeman will come and want your custody again. So it's better that you continue in custody. So where bail and not jail is a right.
No, it is.
Yes, it has been turned on its head in various harsh draconian legislation. That's like UAPA.
UAPA was strengthened in 2019.
Yes.
Immediately after Mr. Modi was re-elected as the Prime Minister.
Yes.
The UAPA was, it's a very old law, starting from 1967, but it has been strengthened by successive governments. And
so all these harsh laws, denial of bail and all that, was justified saying that it is a peculiar nature of the crime. Right. Now, those standards are going to be routinely applied.
Apply to almost every kind of crime that.
Yes. So you and I have a fight. I being a lawyer, I say that Nilanjan Mukhopadhyay tried to kill me.
Right.
I have a particular friend in some particular police station. Oh, the attempt to murder, put him in. I will investigate. Give me 2 days remand, and it will go on and so on and so forth for at least 3 months.
I want to understand one thing very basic. In the last few years, people like us in the media and also within the legal profession, lawyers like you, there has been a debate that there are some laws in the IPC, some sections of the IPC, mainly the IPC, which actually defines what kind of crimes are there. There are some which have not been altered at all from the colonial era, and they need to be dropped. Sedition has been one of the points on which there has been a kind of a unanimity within the media, civil society, the legal profession, and even academic circles, that sedition is something that must be now buried, in the 75th year after independence, it should be buried, and we should go ahead. Now, while you actually make a point which is actually could be a bit confusing for the people who are watching our program, that while in letter this does not exist, it continues to exist in spirit. So is there some kind of a new kind of a sensitivity against any form of protest, which is a very legitimate act in a democracy? Is it being delegitimized? Is any voice of protest, are they going to be, squeezed and, suppressed under these new sanhitas which are coming in?
Well, you could be suppressed under the old ones by saying sedition. Sedition could carry a small sentence, but it could go all the way to life. And so again, if the state strongly opposed bail, then it was problematic. Now, the Supreme Court wanted to re-examine its earlier judgment, which upheld the validity of the section with riders. They said you spread disaffection and immediately an act of violence is caused as a result of that speech, then a case is made out, otherwise no. That gloss that the Supreme Court put on was forgotten. It was routinely misused. Now what they've done is in the proposed act, they've just taken the word sedition out, but they've put in all kinds of sections which can be which are what we lawyers judges call overbroad, which can be used to target any kind of speech, any kind of criticism, and they can say, oh, we got rid of sedition, but they have substituted their own versions of spreading disaffection, which will get everybody else into much more trouble.
There has also been considerable, discussion over the fact that adultery has been introduced for both sexes, for males as well as females. Can you explain it, that how and what, this is going to be very dangerous for the citizens, the introduction of adultery as a crime in
the Supreme Court.
Nyaya Sanhita?
Yeah. See, the old law of adultery was basically premised of making the adulterous act criminal, was basically premised on the fact that, the outraged husband must not take action himself against the other man. And so it was only men who could be liable for criminal punishment under adultery. So that got challenged in the Supreme Court, saying that, look, this is irrational classification. It's two people commit adultery together. It can't be that one person is punished and the other is not. And the Supreme Court struck it down. So now they say, okay, not only the man, but the woman is also guilty. We will prosecute both. And the consequence is that all sex outside marriage is likely to be criminalized.
So is it going to lead to erosion of privacy of Indian citizens?
Of course. That yes. What business does the state have in anybody's bedroom? As long as two adults are in a bedroom together and consensually, the state should just back off. It has no business to check, oh, were they married? Were they rightly married? If they are married, are they cheating on somebody else? None of this should concern the state. But
it can be argued, that social values have to be protected. We cannot allow moral degeneration of society, that people must conform to what is considered to be right and wrong as far as the majority is concerned. And, adultery is in any way something which is immoral, that we are actually trying to protect the morals of society. That could be the argument.
Well, that is also the argument for prohibition. Have you stopped people drinking? Even in Gujarat? No.
It does not stop people from drinking, but legally, well, it cannot be, one of the...
So the consequence is that if you make stupid laws, your courts will be clogged. Please look at the prosecutions in the state of Bihar. For this kind of stupidity goes across the board. If you try to regulate every faction, everything in human life, if you say that, social norms require that people eat only with the right hand, and to prevent that, we are going to criminalize anybody who uses his left hand while eating. You can make a law. Okay. You have the power to do so. The question is it wise? And what would the consequence be? Because then if you have to have a trial, you would have to have a trial to prove that so-and-so ate with his left hand, where so-and-so saw it, so-and-so photographed it, this is the evidence, this, that, and the other. And the defense would equally well argue, no, see that photograph was morphed, various things. I'm just giving you a small example. So therefore, to use the Prime Minister's own phrase of minimum government and maximum governance.
Trying to maximize government.
So here
maximum government minimum governance.
Hence, that is what is going to happen. When Nitish Kumar brought in prohibition, and just before that, I was addressing a meeting in Patna.
Right.
I said, thank you, Mr. Nitish Kumar. You have provided the lawyers of Bihar so much work. So much work. And many of the bail courts in the criminal system are just clogged with that. So if you make a criminal law, if you decide to criminalize anything, you should have what is called a litigation impact assessment. Right. Are you going to add to the burden of the system?
In fact, you refer to it in your article. You say that, courts have often bemoaned the government's rushing into legislation without doing a litigation impact assessment. And you refer to criminalization of check bouncing under Section 139 of the Negotiable Instruments Act. That it has completely clogged the judicial system. Numerous cases, innumerable cases. Initially, there would be reports in the media, about it clogging the judicial processes. But now even we in the media have become very cynical about all these cases which are pending and clogging the system. I just want to put it on record. You referred to prohibition. You talked about Gujarat and Bihar. Based on travels extensively in these two states, I can say that it works only in word, not in spirit. There actually, in both places, there is a fairly well-oiled home delivery system. You just have to know the right people to get the telephone numbers. And these days, in the era of mobile technology, these are very easily available, in both states, and it has, prohibition has actually never worked anywhere in the country. It just, shows, that raises the fear that adultery is going to become yet another intrusive way of actually, penalizing citizens who have to be quote unquote fixed by the local policeman or
yes, by just to add there.
Yes, please.
Because of prohibition,
yes.
A policeman can in Gujarat or Bihar can always come into your backyard and say, I found bottles there, and fix you. Yes. Right? So now once you have adultery you have a visitor of the opposite sex in your house. Any policeman can barge in and say, no, adultery was going on. Just can you imagine the quantum of stupidity that will be at play? So it's many of these, it does appear to me that there was anyway a project to rename things. Okay, I would have had no objection if they'd taken the existing codes and just renamed them the Bharatiya so-and-so and the Bharatiya this and that. No problem. But to justify the exercise of renaming, rebranding and all that, you start
decolonizing. We are actually the champions of decolonizing.
Yes, so to decolonize things, you have to pull up everything and put it together, not in the same the original fashion, but your ground floor has become the fourth floor and vice versa. So this will also lead to another quarter century at least of fresh litigation and fresh interpretation.
There is another area which I am very extremely worried as to how the ordinary citizen or even somebody who has a viewpoint which is which is contrary to that of the ruling party or the government. That is absolutely just legitimate to have a contrarian vision or a viewpoint in a democracy. Now it says that section I was reading somewhere that section 150 of the Nyaya Sanhita now, it is going to criminalize acts, I'm quoting, acts endangering sovereignty, unity and integrity of India. It says criminalizes words, signs, visible representation, electronic communication and use of financial means, etc., etc. But the basic question that what are these? Who is going to determine that which word is a criminal word and it should not be used against the state or against the nation? Because suddenly we have become, in the last 9 years, we have become hypersensitive about the state being attacked by the people. Any way, any person who says no to anything is being labeled anti-national, a seditious person, and a person who is not patriotic enough.
So yes, and the thing is, who is to determine? That's the key question. So the first determination will be by the person who wants to be seen as a leader, a neta in the making, who wants to take offense. Says, oh, so and so has said this. This is against national interest. So supposing I said that India played horribly in the World Cup final.
It could be considered to be.
Yes, it is against the national interest. No. We scored 240. We had them down at 46-3 or something of that kind. And we played very well. Luck didn't favor us. To say that we played horribly is anti-national. Now, so you have a neta who will barge into a police station. Now, what does the policeman do? The policeman knows that if he tells the neta, look, I'm not registering a case, no case is made out, then he will have people calling him up. So yes, so the safest thing is register a case, pull the chap in, put him inside, and then let him fight for bail. By the time the bail process goes through the various levels of the courts, you are very near a maximum sentence. So more and more law means less and less governance,
right,
and less freedom.
Right.
Long ago, somebody said that eternal vigilance is the price of liberty. And this is what the people of this country should say. Why are you changing the law? What is that overweening necessity?
Right.
Decolonization, can you not achieve it in some other manner? You want to change the name, please change the names. Otherwise, what was so colonial about the old law, and what is so anti-colonial about the new law? Please tell us that.
There's also the question of the tearing hurry. We are at a time when we are just barely less than 6 months away from the next parliamentary elections. In fact, you put it very succinctly with tremendous point. You say that if the introduction of these 3 new laws was actually the shilanyas of a police state, then the parliamentary report which has been submitted to the government is actually, the pran pratishtha. So we are basically looking at this entire election has to be, looked at the Bharat India issue, the Ram temple being inaugurated on the 26th of January, and the 3 new laws, essentially to create a new, some kind of an overarching political narrative for the next election. That is the way your legal, sharp legal mind would be looking at these developments?
See, I may have a legal mind, I may not have a political mind. And a political mind, yes, everything is Bharatiya, this, that, and the other. It will resonate with the masses.
Right.
But legally, what I see, and forget this government, forget that government. Governments worldwide want more and more knowledge about individuals. They want to have more and more effective control over the individuals, and whether directly or indirectly through their policemen, want to be in a position where they shut down the inconvenient, and the rest exist in a situation of fear and trepidation. So that is not freedom. That is not freedom. And any government that takes it away, even if that government goes into the opposition, the next set of people who come in are very, very unlikely to reverse the course. So therefore, don't jump to make a bad law. Don't jump to make a bad law and say, oh, it will be good fun when we can use it against the other side.
Right. After all, we refer to the UAPA, and we cannot
Yes.
forget that the law was first introduced way back in the late 1960s. And from then onwards, every few years, it has been strengthened further and further, which has weakened the rights of the citizens more and more. One last
Yeah,
question.
just 1 minute before you come to the last question, that UAPA thing, that
Yes.
again is an example.
Right.
Why did the UAPA come in? That was because in the early years after independence, and there was a certain sense of feeling in the South that, maybe we didn't get a good deal, we need to secede. There were parties there which said we need to secede.
Yes.
So for that, around
Not in for a
67,
specific context.
yes, it was brought in that context. And it lay in the statute book, sometimes used to be tweaked and all that. Then we had terrorism. After Mrs. Gandhi was shot, then we brought in TADA. We brought in very harsh laws to deal with terrorists. But we ended up, criminalizing and making terrorists of a lot of our citizens. So Parliament itself had to get rid of TADA after some time. Then you brought in POTA. Again, the same thing. Again, you have to take it off. So now instead of reenacting something, an old enactment was refurbished, amendments were made, and UAPA has become a thing. PMLA was similarly, which was meant for drugs and arms, has gone into so many other things.
That's true. Become extremely draconian. I was asking you about the last question. This has to be a bit on the lighter side, because we've had a very politically charged and a very interesting discussion trying to discuss these three laws. Laws have also been part of our daily culture, in the sense that it is part of our vocabulary. 420. 420 has been used, universally to brand people, which is saying very jokingly, don't behave like a 420. Cinema uses so many, legal laws are referred to in cinema. I can pull out one film after another in various languages, all the languages that I know, where various laws are being done, and people immediately know. People know what is Dafa 302, what is Section 307. People know all that. Now, all that is going to be changed, and you also point out in the article, lawyers, court staff, judges, hundreds of thousands of people will have to go back to the law books, the new laws which will become, provide the entire backdrop. So how much of time is going to be wasted? Is it really very necessary? Culture to law, such a vast region has to be, everybody has to relearn so many new things.
No, relearning just the numbers and all that may not be a problem. But now, if the same section is reenacted, not in this chapter, but in some other chapter, then there will be arguments on context. Does it mean the same thing?
Right.
So there will be a whole host of lawyers who will have to make those arguments. Whole host of judges will say, no, it is the same thing. Or they may say, no, you have a point there. Therefore, we must assume that the legislature meant this. So the law being unnecessarily unsettled,
right,
is not conducive to healthy governance.
Well, very well put, Mr. Sanjay Hegde. It's been really wonderful speaking with you on the three criminal laws to replace the Indian Penal Code, the Criminal Procedure Code, and the Indian Evidence Act. We hope that Parliament will actually reconsider voices being made by various people, including, through this program, your very forceful voices, and maybe not rush into it. Keep it for the new Parliament after the elections to actually decide whether we should have, quote unquote, a decolonized legal set of laws or not. Thank you very much once again.
Subscribe to the Federal's YouTube page for more news and updates.